Joseph Sellers. Mr. Sellers is a partner at the law firm of Cohen, Milstein, and is head of the firm's Civil Rights and Employment Practice Group. In this capacity, he represents victims of discrimination and illegal employment practices individually and through class actions. Prior to that, he served as head of the Employment Discrimination Project at the Washington Lawyers Committee for Civil Rights and Urban Affairs for over 15 years. Mr. Sellers has also been active in legislative matters and worked on the passage of the Civil Rights Act of 1991 and the American for Disabilities Act of 1990. He received his BA from Brown University, his law degree from Case Western Reserve School of Law.
When it was enacted in 1963, the Equal Pay Act, the first federal sex discrimination law that had been passed for applying to the workplace, held great promise. But it has fallen far short of that promise because of a number of procedural flaws in the legislation, many of which the Paycheck Fairness Act would address. I want to identify a few of the areas and begin with an area that has not been discussed, and that is the initial burden that women who wish to invoke the Equal Pay Act must satisfy in order to even shift the burden to the employer to have its business practices scrutinized. The factors that must be satisfied are difficult to satisfy, typically requiring expert analysis that most individuals cannot afford to pay, and therefore many women stumble at the beginning of pursuing these claims when they pursue them individually. So I'd like the subcommittee not to begin its assessment of this bill by assuming, as might otherwise be led to believe, that these claims are anything but very difficult to bring under the best of circumstances. We've already discussed briefly among the panel the catch-all defense, the factor other than sex that can be used by employers to defend these claims. That defense can permit such practices as strength and agility tests or prior pay levels at the time before employees are hired to be used to justify existing pay disparities between men and women in the workplace, and simply because they do not on the surface reflect an intention to discriminate or reflect some basis to be inclined to discriminate, they may satisfy this factor other than sex standard. And so I applaud the Paycheck Fairness Act's proposed changes here, which do nothing more than import into this statute the protections that were already accorded to workers in the Civil Rights Act of 1991 as it applied to disparate impact claims. There's nothing revolutionary about requiring that the factors be bona fide, that they be related to the job in question, that they be shown to serve a legitimate business purpose. Those are hardly extraordinary requirements, and that is what this provision would require. I turn quickly to the issue of multiple party claims, class actions. I think there's a good deal of misunderstanding perhaps about what this bill would accomplish here. I've represented employees for nearly 30 years in a number of pay discrimination cases, and I have found repeatedly that they are, as I think Dr. Murphy mentioned at the beginning, there's a great deal of fear about suing your employer. And the provision currently in place, which is simply an anomaly because this act was, the Equal Pay Act was an amendment to the Fair Labor Standards Act, it requires that each woman who wishes to participate in these cases has to file a notice to her employer and take some affirmative action to actually participate in the case. In practice, that leads to often fewer than 50% of women aggrieved with respect to a particular pay practice actually participating. That is hardly the goal we should seek to achieve unless your goal is simply to minimize liability for an employer. And that is certainly, I would hope, not the sole goal of our nation's civil rights laws, but rather to do justice. And those women who are aggrieved ought to be given the opportunity to participate in these cases. The Act would simply add to the law a provision which is applicable under Title VII, applicable to virtually every other modern civil rights law, that individuals who wish to pursue a claim as a group can invoke the rules of civil procedure applicable to all cases in federal court, and therefore people who are aggrieved can participate in those cases whether they initiate their own action or not. So it really puts this law in parity with the other civil rights laws. The remedies, I will say only one thing quickly about that, and that is by simply awarding to aggrieved individuals their earnings lost and occasionally double the earnings lost, it provides no deterrent to employers to ensure that their pay practices are fair. It's simply, as has already been explained, potentially the cost of doing business to discriminate on the basis of pay. And finally, last point I make to conclude quickly is I really want to stress the importance of the reporting requirements that this bill would add to require employers to present data about pay to the Office of Federal Contract Compliance Programs and the EEOC. As Justice Ginsburg in the Ledbetter decision recognized, most employees don't know how others are paid, lack the basis to make those comparisons. We need the federal agencies to collect that information in order to provide the proper enforcement. Thank you very much.